Serial number 20, Kiran Kumar Sinha versus the State of Bihar for the petitioner Sri Sunil Kumar.
Obliged.
May few lords. By way of the present writ application, my lord, the petitioners pray for a direction to make payment of salary during from 13 to 2008 to 22/6/2009, my lord, during which the petitioners were under dismissal, which has been illegally passed by the authority concerned, MT Biada, my lord, without initiating any proceeding and without any show cause notice, my lord. And against the, that is Annexure 2, my lord, under
Where
the,
is your representation?
pardon, my lord.
Where is your representation?
Representation, my representation is, my lord, Annexure 16, my lord.
Annexure?
Annexure 16,
Page?
page 103, my lord.
10?
103 of my brief. Annexure 15 and 16. 15 start from over.
No, where is the signature of the petitioners in this?
Kindly turn to page 100, my lord.
100?
Page 100, Annexure 15, my lord. The signature of all together 30.
Yes, who is appearing for respondent?
44 implies has been made, my lord, at page 101 and 102, my lord.
Yes, sir, who is appearing for respondents?
Your Lordship, I appear for the Biada, Your Lordship. Here is a case, Your Lordship, when these petitioners who have come before your Lordship, they have taken the order of reinstatement based on the order of this honorable court, and the honorable court's order got merged with the LPA, wherein the undertaking of the Biada Employees Association was that for the termination period we would not take salary, and we will take salary from the day of joining. This was an undertaking given before the division.
Salary will be taken?
From the day of joining again. For 1 month they were out of service, and now before the LPA court the association came and
where is that undertaking recorded by this court?
Your Lordship, the division bench order.
There are several. May I permit it to clarify some points, my lord? That is
Annexure 10, Your Lordship.
Annexure?
10.
10 of this writ application.
It starts from page 88, my lord. Relevant.
Petitioners are party to this LPA?
No. We are not in LPA, my lord.
Your Lordship, but they got their reinstatement on the basis of the order of these. They were before the appellate court. Your Lordship, may I clear the facts in 2 minutes, Your Lordship? After termination, there were some.
The petitioner services were terminated.
Your Lordship.
On what date?
Your Lordship, it was the entire employees of the Biada class 3.
All right, you give me a date. On what date they are terminated?
13 to 2008, Your Lordship.
13?
To 2008.
2018?
8, Your Lordship.
8. Terminated. Then?
Your Lordship, thereafter some of the employees came before this honorable court, and some employees went before the appellate authority of the Biada.
Now, insofar as petitioners are concerned, they
were before the appellate authority and thereafter, in the meantime, this honorable court in 3-4 matters on which the petitioners have relied, set aside the termination order.
On what date?
Your Lordship. The order of the honorable court is. That is page 82, Your Lordship, dated 24/2009.
24?
20th April 2009.
Then what
Now,
happened?
quoting this order before the appellate authority, the petitioner said that since the High Court has set aside the termination, even our termination may be set aside in light of the order of this Honorable Court, especially in the case of 14837, which is recorded in the order of the.
No, appellate authority allowed the appeal.
Allowed the appeal,
On
saying
what
that.
date?
Allowed the appeal, Your Lordship.
Appeal has been allowed, my lord,
First
on
of June 2009.
1st of June 2009, my lord.
First of
June 2009.
2009.
Your Lordship.
Annexure 6.
Your Lordship. And thereafter, Your Lordship, the Biada went in LPA.
No.
May I clear first?
My-
Biada went in LPA after
Who went in appeal?
Biada, the authority,
Authorities filed LPA.
LPA.
Ah.
In
What
the same,
happened?
for the same cases in
Ah.
which, for the same 9 cases, taking the plea of which the termination was set aside, in which the termination was set aside. In LPA, Your Lordship, this is the order which I have just, the Employees Association came, they said we want our reinstatement and we would not take the salary for the period we are out of service, we have not worked, and we'll take salary from the day we join. Recording this, the LPA court directed, disposed of the matter. So
Where is the portion in which the LPA bench has recorded?
Your Lordship. There was a resolution, Your Lordship, page 89.
Hmm?
Page 89 of the writ application, Your Lordship. Your Lordship, I'll read from the above, page 89, that in the said letter, there was a letter submitted before the Honorable Division Bench, and in that letter it was stated that the employees have referred to talks held with the management, and request has been made to accept their joining being submitted by the concerned employees, so that from the date of their joining, pay and other emoluments may be paid to the concerned employees. The employees assured that the management of full cooperation of discipline on their behalf. In the third supplementary, categorical statements have been made in paragraph 1 and 6 that writ petitioners have so signed in the said letter, and the authority, after considering their representation and undertaking, wants the LPA to be disposed of in terms of their undertaking, because there was an undertaking that they will not in the last date, and therefore in light of that the LPA was disposed of.
Whether the petitioners have given such undertaking?
Your Lordship, the petitioners have got their reinstatement on the basis of the writ
No, all right.
application.
Whether have they given undertaking?
They were not before the division bench, Your Lordship.
Then how are it is inter parties?
Your Lordship, they went on a strike on the call of the association. Now
No,
they
it-
joined on the call of the association. So
That is
now
a-
for this,
That is a different aspect.
Your Lordship, this is the they cannot.
LPA decision is binding on the inter parties, who are all parties to that proceedings.
Your Lordship, but on
The
base,
petitioners are not party to that proceedings.
but Your Lordship, based on the order of the Honorable Single Judge, reinstatement was done on the basis of the order,
Correct, but in
and
the-
that merged with the order of the
If
LPA,
that is the
Lordship.
case, have you, the appellate authority has modified the order dated 1/6/2009?
No, Your Lordship.
No. Then?
So
Sorry,
with the
ma'am.
order. Your
And
Lordship,
the division bench judgment has also been reviewed.
Has also
No,
been
that is
reviewed
in case
by-
of only one person. That
Not
is again in
division
case of one person.
That has been reviewed.
That LPA order has been reviewed, my lord, that
It-
No,
judgment
we
is
are not
written.
concerned with the division bench. Whether appellate authority has reviewed, or have you questioned the appellate authority
No, Your
order?
Lordship, it had said in the.
1 second, please listen. Against the appellate authority order, have you filed a writ petition?
Your Lordship, in the, 1 second, Your Lordship, in that order of the appellate authority, it had said the order would be subject to any modification in the order of the writ.
Where is the modification?
It would be subject to any change in the order of the Honorable
can it
Single
be?
Judge.
How can
That
it
was
be?
that, Your Lordship, I'll just read out that one line, Your Lordship.
Where is the appellate authority order?
Your Lordship, that is
Appellate
an
authority order is annexure 6, my lord.
Page-
69.
69.
69. It starts from 69, my lord. A relevant part is page 75, my lord. Allow these appeals setting aside the interim termination order. However, this order shall be
Subject to any review of
the-
these High Court orders, and after stay, modification extra of these orders, if any, on
Where
a
is
second.
that observation, madam?
Your Lordship.
And para para 7 of the appellate authority order in
No,
view of the
there is no para 10, para 7 is the last.
para 7 is the, I am submitting para,
Para
7.
seven.
Para 7.
Read para 7.
In view of the Supreme Court decision cited above in para 4, I am inclined to allow appeals made by the learned counsel of the BIADA, plea made by the learned counsel of the BIADA, particularly because charges have not been denied, and only thing that remain to be examined in such circumstances in quantum of the punishment in the light of the of proved charges.
Not
However,
denied charges.
in view of a completely different stand taken by the Honorable High Court in similarly situated writ cases referred to it in para 2 above, I am on
I
no
have no
option
option
but to allow these appeals setting aside the impute termination order.
However,
However,
this order shall be subject to any review of these High Court orders and after stay, modification, etc. of these orders, if any, on a second indulgence or
No,
otherwise.
High Court order has not been modified or
Merged.
reviewed.
It has merged with the order of the LPA, Lordship. LPA order, Your Lordship, now the single judge's order would merge with the
No,
order
no.
of the LPA, Lordship.
High Court order has not been reviewed. On the
It has
other
not
hand,
been reviewed.
High Court order was subject matter of
Your
LPA.
Lordship, if in LPA,
In
the
the
order.
LPA, the respondents are given undertaking. How is it
Your Lordship,
relevant?
if LPA would have been allowed, then then automatically the basis of acceptance of setting aside termination order would also go. So in that same case, how the single judge's order would merge with the order of the LPA
Correct,
court,
but the
Lordship.
petitions were not before LPA.
Your Lordship, but they had, Your Lordship, for that, Your Lordship, what I submit is that because the call was on the, on call of the strike,
Madam,
of the
you
association.
should have approached this court in respect of modification of the appellate authority's order in
No.
filing writ petition in the light of LPA decision.
LPA has been filed, my lord, against the order dated 21/4/2009, my lord, passed in CWJC number.
Sir, you are not a party, sir. Please don't. Yes, take down. The instant petition petitioners have prayed for the following relief. Full stop. Among petitioners, among others, services were terminated on 13/2/2008. Full stop. Petitioners preferred appeal before the appellate authority in respect of challenge to the order of termination dated 13/2/2008. Full stop. Similarly situated persons whose services were terminated, they invoke writ jurisdiction remedy. Full stop. Their writ petitions were allowed on 20th April 2009 during pendency of the petitioner's appeal before the appellate authority. Full stop. The appellate authority followed the orders of the learned single judge dated 20th April 2009 and proceeded to set aside the order of termination. Full stop. When things stood thus, respondent authority, feeling aggrieved and dissatisfied with the order of the learned single judge dated 20th April 2009, preferred LPA. Preferred LPA number so and so. During pendency of LPA, contesting respondent in those LPAs gave a concession before the division bench to the extent that they are giving up arrears of salary during the intervening period from the date of termination till reinstatement. The same was recorded and LPA was disposed of. Twist up. In the light of these facts and circumstances, question for consideration is whether the petitioners are entitled to salary during the intervening period from the date of termination till their reinstatement or not. Twist up. Undisputed facts are that petitioners and others services were terminated on 13/2/2008. Twist up. The petitioners and others have a remedy of appeal before the appellate authority. Twist up. The petitioners invoke remedy of appeal. On the other hand, similarly situated persons invoke remedy of writ jurisdiction. Twist up. In the writ petition, the writ petition were allowed on 20th April 2009 while setting aside the order of termination. Twist up. Taking note of order dated 20th April 2009 read with other decisions of the various High Court and Supreme Court, the appellate authority proceeded to allow the petitioner's appeal on 1/6/2009. Twist up. The appellate, respondent authority preferred appeal, LPA. During pendency of the LPA, contesting respondent gave a concession before the division bench to the extent that they are giving up arrears of salary from the date of termination till reinstatement. The same was accepted and disposed of. Twist up. The undisputed facts are that the petitioners were not parties to the writ petition and LPA. Full stop. Therefore, whatever the decision passed by the LPA, passed in LPA, is binding on the inter parties and not the petitioners. Full stop. Merely because contesting respondents in LPA matter that they had given concession to the extent that they are giving up arrears of salary during the intervening period from the date of termination till reinstatement. The same yardstick is not applicable to the petitioner for the reasons that they were not parties to the aforesaid proceedings. Aforesaid proceedings in writ as well as LPA. Twist up. Moreover, respondent authority had a cause of action in denial of arrears of salary to the petitioner in questioning the appellate authority's order dated 1/6/2009 before this court with reference to LPA decision. Twist up. At this juncture, it is to be noted that salary of an individual employee is a service condition relating to an individual. Twist up. Merely a set of employees gave a concession before this court in a LPA decision. Such a concession given by such of those employees are not binding on the petitioners. Twist up. In the light of these facts and circumstances, the petitioners have made out a prima facie case in respect of claiming arrears of salary during the intervening period from the date of termination dated 13/2/2008 till the reinstatement. The same shall be calculated. Full stop. At this juncture, it is relevant to reproduce a PESCO decision in the case of Sri Chamundi Mopeds versus so and so, reported in 1992 supplementary 1 SEC. Para 10 reads as under. Full stop. In the aforesaid decision, Apex Court has dealt with what is the effect of quashing of an order. Full stop. If an order is quashed or set aside, then whatever the position as on the date of such order would restore. Full stop. In the light of these facts and circumstances, the petitioners have made out a prima facie case. The concerned respondent is hereby directed to, respondent authority is hereby directed to calculate arrears of salary in respect of each of the petitioner and disperse the same within a period of 3 months from the date of receipt of this order, failing which the petitioners are entitled to interest at the rate of 6% per annum.
Obliged.